Carolina. That's the trial of a son who was accused at one point of joining his father on a multi-state crime spree. This case involves the death of a husband and wife in North Carolina. The father committed suicide in custody, so he will not be joining his son in what has turned into a capital murder trial in North Carolina. North Carolina has a capital murder statute, but they don't frequently employ it. So does that generally mean that juries there are saving the death penalty for the absolute most egregious, most serious murders that they come across? And is it possible that the son's defense that he was just swept into this thing along with his father, might that be enough to mitigate the death penalty in a state that doesn't frequently apply it?
I would hope that his defense attorney could bring enough mitigating factors to the light that, the death sentence wouldn't be imposed. Certainly this kid, if he's convicted, is going to get a very harsh sentence. I do think he was the victim of a drug-addicted, abusive, depraved man whose own wife had to escape in the middle of the night, and he really, he was dragged along through this thing, like a Stockholm Syndrome type defense.
Well, I mean, the testimony from the abuse within the family last week was pretty compelling, as I remember it. She's talking about being tied up in such a way that if she tried to escape, it would like hang her or something like that. I rember some of the testimony.
Yeah, I mean, that is absolutely, disgusting behavior. This guy was a real monster, and, I don't think that the kid should be punished. On the other hand, putting my prosecutor's hat on, not a hat I wear very often, he is an adult. This was a multi-state crime spree. He had ample opportunity to get away. There was a point even when the father was incarcerated briefly in Texas where he could have, bailed out. He could have escaped at that point. Instead, he chose to bail his father out. So I don't know, it's a tough one.
Well, to get out of a conspiracy once you're in it, you have to take affirmative steps to get out, and there's no evidence that the son did that. So it would seem to me that the charges might stick just based on what you alone mentioned here.
Yeah.
So you did put your prosecutor's hat on, and you did win the argument for that side.
Well, I'm going to put the defense hat back on, and I would say, look, this kid is so traumatized. To the objective person, yes, he could have removed himself from this situation, but that's looking at it objectively. After, suffering decades of abuse and torment and just the authoritative manner which the father conducted the family affairs, I don't know that in his mind there was ever any escape.
There may not have been, and we've been watching the Campbell case, and again, we've got these family pictures that make everything look nice and buttoned up here, but we had testimony behind the scenes of that very photo last week that indicate that the image belies the reality. So it's a case that we've had to cover in bits and pieces here. We should be back with it this week, pending its outcome, and the Urich case, though, has gone on longer than expected. We had a full day of defense testimony today, and that's going to spill into the day tomorrow. This was supposed to be wrapped up last week, so this trial is taking quite a while. The prosecution called 21 witnesses. That's quite a few witnesses for a case like this, and we know that someone did die in the crash, but we've seen quite a few witnesses here, and there are still factual scenarios to be resolved by the trier of fact, in this case the judge, as to whether or not the defendant truly was impaired from drinking alcohol earlier that day. We know alcohol was consumed. We don't have any testimony that his eyes were bloodshot, that he was slurring his speech, that he smelled of alcohol in the hours after the crash. So, okay, well, consuming alcohol is not a crime. You can drive after you've consumed alcohol. You just can't do it while you're intoxicated or while you're impaired.
Yeah.
Does it look like he did anything illegal as it relates to the charges that require evidence of impairment?
Look, I mean, with respect to the amount of witnesses they've called, what did you say? It was something of 21 witnesses.
Is my count for the prosecution.
Sometimes the prosecution likes to overwhelm with the quantity of witnesses, but not necessarily with the quality. I've had cases where, 10 prosecution witnesses, and I only called one witness, and we got a full acquittal. I do think this is a case where I don't think this man has any criminal convictions. He might have some traffic violations for speeding. He might be a good client to put on the stand. He's a doctor, he presents well, he's a relatively upstanding citizen. It might be good to put him on the stand and hear some testimony that he didn't know what he hit. Maybe he could testify to how fast he was going, and maybe he could defeat some of that evidence of the impact or the eyewitness testimony attesting to the fact that the boat seemed to be moving at a fast pace. I think he could be particularly useful if he can testify in a way that benefits himself.
Well, that gets into a sticky area, and the reason why it gets into a sticky area is because the whole, failure to stop. He's going to have to say, I thought I hit a rock, and I think the greater fear is not so much the outcome of the criminal charge, but if he says anything that could result in a perceived self-statement of dishonesty on the stand, that has medical license implications, and I think that's really sort of the end game here is to try to avoid the felony and keep the medical license. Because, okay, so if he gets nailed on the last charge, the misdemeanor, again, I keep saying this, that doesn't affect his medical license. But if he says something that could be perceived as dishonest, then you talk about license implications that could affect him long after the criminal case is
moral
over.
turpitude.
Yeah.
Look, I think he would have to be really prepared to testify. Whenever I've had a client or any witness really testify, I prepare with them for hours. I prepared one guy for upwards of 20 hours to testify, and he may have testified for 2 hours tops. He needs to be prepped on what questions are going to be asked on direct, how he should answer them, obviously always answer them truthfully, and he should also be prepared with a mock cross-examination, questions that the prosecution might ask. But I think he could do a lot of good for his case here. He's not someone that, if they put him on the stand, the prosecutor's not going to be able to impeach his credibility by a prior criminal history.
The other thing he has are some prior speeding things, but I don't know if they would necessarily come in.
May not be relevant. Could be relevant given the allegations that the boat was speeding. However, just because someone has speeding tickets doesn't mean that they should be disbelieved entirely when they testify.
Yeah, I'd have to really think through the evidence analysis on that to see whether or not it would stick. But want to go back to some of the previous testimony in the case. We've been listening to some of the testimony of Gregory Johnson, who was one of the investigators who was at the doctor's house after the crash. The reason we've been going back over this is because the doctor's wife was on the stand this afternoon, and many of you listened to her testimony in full. And so much of what she said is corroborated by the so-called disinterested, the independent sheriff's investigator, that I think that any evidence that the wife was somehow trying to cover the husband, I don't know if those accusations would stick in this case, because she's really saying the same exact thing that the law enforcement official is saying. So we'll continue listening to some of his testimony. We'll be back in about 10